Hi, my name is yunus.lunat. I'm a partner here at Ison and I head the Employment Law Department. The reason for that is that the main effect of this agreement is that it prevents the employee from bringing any claims in a tribunal at a later date. So it will list all the claims that theoretically may have become possible, may have arisen during the course of the employment, so it boxes them all off so that none of those claims can be brought at any time in the future. The agreement will not always state the reason for leaving, and it doesn't necessarily have to be accurate as well. What I do recommend is that the agreement should include an agreed reference as an appendix to the agreement, and that reference should set out the reason for leaving, and that reason should be agreed between the parties and acceptable to the employee. An agreed reference is the reference that will be provided by this employer to any subsequent prospective employers. So when the employee looks for new employment and he puts this employer down as a point of reference as my last employer, then everybody knows that this is the reference that will be provided, so it provides certainty and it provides peace of mind for the employee going forward. Agreed references nowadays are very short and factual reference. They simply list the name of the person, the dates of employment, the role held, and date of departure, and usually reason for leaving. It won't provide any qualitative information about how good this person was or what the duties involved and that sort of thing. The amount that's offered under the settlement agreement is usually tax-free as long as it's below the £30,000 limit. However, it's only the termination payment that's tax-free up to the £30,000 limit. The settlement agreement will also usually include a payment for notice in lieu. That element is taxable because it's paid under the contract and it's part of wages. So that any notice element will be taxable, any holidays accrued will also be taxable, and any wages outstanding up to the date of termination will also be taxable. The termination payment, that's the redundancy payment plus any ex gratia sum offered by the employer for signing the settlement agreement, is tax-free up to £30,000. Settlement agreements are always offered on a without prejudice basis. What that means is that it is not binding and conclusive until it has been signed by both parties. So until that point, either party is free to renege and back out of the agreement or even seek to renegotiate on it. It is important that both parties are able to comply with the terms that are agreed. Failure to do so can obviously have consequences, particularly when it relates to payment amounts and dates for payment. So it's important that the employer keeps to the dates for payment. And then for the employee, there will be things such as returning the company property by an agreed date, keeping the terms of the agreement confidential, so not to tell anybody about them, and not to make any derogatory or negative comments about the employer and his business and his employees. The last item, the disparaging comments, should ideally be mutually both ways. So it's important that both parties comply with the terms of the agreement. What would normally happen is that the employee will have been offered a sum of money to leave employment. That is, in many cases, open for negotiation. So there is no harm in instructing a solicitor, such as Ison to negotiate on your behalf. It is possible for fresh post-termination restrictions and obligations to be included within the agreement. They are totally a matter for negotiation, so the employer can propose them, and if the employee thinks he's willing to sign them in return for the payment that's been made, then fresh post-termination restrictions can be imposed in the agreement. They will nearly always repeat any restrictions that are in the contract of employment, but it is possible to impose fresh post-termination obligations at the point of departure to reflect any progress that the employee may have made within the business. Once an offer is made, a reasonable amount of time should be allowed for the employee to consider the proposal and to take advice. ACAS guidelines stipulate that 10 days should be, at least 10 days should be allowed for advice to be taken. A protected conversation is a conversation usually opened by the employer, but it can be opened by the employee, seeking to inquire if the employee is interested in leaving employment in return for a sum of money. It is protected because what that means is that it allows free and frank discussions to be held about performance issues or any other concerns, and protected means that that reference cannot be made to that conversation as the basis for any subsequent tribunal proceedings. So, if the employer has a conversation with an employee about whom he or she has reservations, then the employee cannot then turn around and bring a tribunal action relying upon that conversation and claiming that the employer wanted me out anyway, hence he or she had that conversation with me. There is a cost element involved in advising and signing off the assessment agreement. The employer will always make a contribution towards the costs of the employee taking advice and signing off the assessment agreement. Here at Ison Harrison, we do not seek to charge anything over and above that contribution wherever possible. So, if the employee simply wants to accept the offer and move on, then we will always accept the contribution from the employer. On the other hand, if we are instructed to negotiate, then we have various funding packages available, and we find the most important part of these funding packages is the employee's offer is protected. So we don't seek to touch any of the initial offer that's been made, so that the employee keeps all of that sum of money. I hope this information is useful, but as ever, it's always helpful to take first-hand advice.